Alright guys, time to address the first of the dissents. These are going to be shorter videos because the dissents are shorter than the opinion of the court. Well, this one is. So this one is Chief Justice Roberts' dissent. There are three dissents. This is the first and shortest one. So let's dive right in. Chief Justice Roberts dissents agreeing with Scalia. However, Scalia did not join this dissenting decision. It's an important distinction. That the court lacks jurisdiction to review the decision of the lower courts. What's interesting is that he doesn't cite a whole lot of court cases here. The only court case he cites, besides Hollingsworth versus Perry, which had very recently been decided, but still counted as precedent, I guess, was Post. And he's only cited the dissenting opinion, and the dissenting opinion means it's not the opinion of the court and it's not precedent. So there is that. However, he goes on to say that there's interest in uniformity and stability that justify Congress's decision to define marriage. First of all, this is a nation of individuality, not uniformity. In fact, I think there are a lot of Americans who would object to uniformity being the basis of a law. If I said that everyone should wear green shirts from now on to promote uniformity, it would genuinely be to promote uniformity. But people wouldn't accept that. That's a terrible argument. And honestly, this whole dissent from Roberts disappoints me because it's poorly done. Anyway, continuing. Stability, he doesn't really provide how this makes it stable, how this promotes stability. So he just states that it does. Again, this is weak. So then he says the majority sees the sinister motive that the federal government has generally deferred to the state in definitions of marriage. Now, I want to be clear. The majority opinion included tons of citations from various precedents and various laws and the Constitution. This contains none of those. So, he says that it is true, but none of the prior state-by-state variations had involved differences over something that, and he quotes the majority opinion, he says, is thought by most people as an essential and very definition of marriage to its role and function throughout the history of civilization. This is a manipulative quote because it's taken very much out of context. But that aside, says that, the federal government couldn't treat it. So in the majority opinion, the majority stated that there were always differences between the states in marriage, and that didn't make one state's marriage invalid. And they cited, I think Vermont has the age to marry with consent of parents at 13, which is kind of creepy. Vermont, why? Anyway, and another state had it at 16, which is what I had always heard. Vermont, why are you creepy with 13-year-olds married? Anyway, so basically he's saying, well, that's bold, this is different. This isn't like a minimum age difference. Again, he doesn't supply real example or argument of how, which is anyway, but he does say, which is possible, says it's hardly enough to support a conclusion that the principal purpose, and they did say the principal purpose was to desire harm, basically. This is the principal purpose that the 342 representatives and 85 senators who voted for it, the president who decided it, that it was desired to harm, which is possible, probably wasn't desired to harm. Um, it just does. You don't have to desire it to harm for it to harm. Um, I can, accidentally trip you on the way to school, or better, I can put a book down somewhere in the hall, and you trip on it. I didn't put that book down desiring to do you harm. Doesn't change the fact that my putting the book down did you harm. Anyway, I wouldn't be charged for that, so it's a little bit, but yeah. Um, and then he dismisses all of the evidence that the majority brought up. He dismisses the precedents, the legal, like all the legal code, everything that they brought up, just by saying the snippets of legislative history and banal title of the act to which the majority points suffice to make a showing, at least with some more convincing evidence, that the act's principal purpose was to codify malice, and it furthered no legitimate government interest. I would not tar the political brush of bigotry. So we're ignoring all the evidence. We're just going to attack that one point. And he created a straw man, because they didn't say it had no legitimate government interest. They said the government interests were outweighed by the states' rights. There's a difference. Roberts here is being somewhat manipulative in his dissent, and it makes me not like him. I already didn't like him, but it makes me not like him more. Anyway, so then he says, I disagree with the result that the majority's analysis leads to. This is why you're writing a dissent. He said, I'd like to point out the analysis leads no further. The court does not have before it, and the logic of its opinion does not decide the distinct question whether the states, in the exercise of their historic essential authority to define marital relation, may continue to utilize the traditional definition of marriage. Yeah, that's stated in the majority opinion. I don't know why you had to say it again. Um, so he also quotes Scalia's dissent, because Scalia saw that in the majority opinion, and he said it was unnecessary and mess. And he says, no, the disclaimer is logical and necessary consequence of the argument the majority has chosen to adopt. In other words, states' rights, the dominant theme of the majority opinion, is that the federal government's intrusion into an area essential to state domestic relations is sufficiently unusual to set off alarm bells. And then he says something interesting. I think the majority goes off course, as I said, but it is undeniable that its judgment is based on federalism. Interesting. Anyway, moving on. Majority extensively chronicles Doma's departure from normal allocation, and he says, but he thinks there's a contradiction that it doesn't go the other way. Um, that basically he's saying this case is opening the door to a challenge of the states with definitions, and what are you going to do then? And why doesn't this, apply to other states? I agree, but I don't think that's a bad thing, and I'm not sure how that is a legitimate dissenting opinion on the court. You can't say, I don't like where this case is going to lead to, I'm going to rule against it, because that, even though I think it's unconstitutional, going to dissent, that's just horrible. It's not just essential feature, let me see. Again, he argues that the state's decision whether to expand the definition of marriage from traditional marriage, and why they're not concerned with the idea that it might undermine dignity conferred by the federal government, just as the federal government's intrusion undermined the dignity conferred by the states. And I just have to ask if he's even thinking at this point, because that makes no sense. Moving on. He sums it up by saying, I think this is like Hollingsworth versus Perry, we don't have jurisdiction. Which is not what he mainly argued in his dissent, so I'm not sure why that's the first and last paragraph, because his middle doesn't say anything about that. Anyway, summing up Robert's opinion, a bunch of bullshit thrown onto paper, literally, with no evidence. And there's video 2.